Hello, everyone, and welcome to a special edition of Berkeley Boost. I am Adam Sterling, Executive Director of the Berkeley Center for Law and Business. Before we begin, just some logistical information. And again, thanks everyone for joining us this afternoon. For those of you that will be collecting MCLE credit for this program, we are authorized to issue credit in California, and we've been approved for 1 hour of CLE credit. If you're coming from another state, certification may vary, but we will provide you with a certificate of attendance, and you can check with your local bar on reciprocity. To request CLE credit, we will be providing in the chat a link to provide some information for us to issue your certificate of attendance. Again, you can see that URL on the screen. We'll also shortly be putting a link in the chat box that you can click on and provide that information. And again, after the webinar, we will email you a certificate of attendance. If you have any questions or any problems with this process, you can email us at executive@law.berkeley.edu. A few upcoming programs that we want to share with you. Starting tomorrow and continuing through Friday, we have our annual Berkeley Forum for Corporate Governance. Just a phenomenal agenda there. Goes through 2 full days, CLE credit also provided. We'll put the link up in a bit, but you can find more information at theberkeleyforum.com. And again, we'll put the link up there. We just opened up registration today for one of our most popular online executive courses, Sustainable Capitalism and ESG Online, taught by Professor Amelia Miazat. Again, that's an executive chorus that returns the next cohort March of next year, but we are opening up registration today. Again, we'll share that link. And our next 2 Berkeley Boost, on November 19th, we've got a panel of experts talking about some of the gender issues and Gideon V. Wainwright. And then next month on December 1st, we are talking about investor trust. We're joined by some folks from Edelman to talk about their new report. They've surveyed over 700 institutional investors from 7 different countries on topics from ESG to regulation and beyond. So we'll talk about the results of that. So with that, it is my pleasure to introduce our host for this evening, Professor Abbye Atkinson, who is a faculty fellow of the Berkeley Center for Law and Business and is a newly chaired class of 1965 assistant professor of law at Berkeley. So I will now turn it over to Abbye. Before I do, we will be taking questions at the end. You can ask your questions throughout this conversation. Please use the Q&A feature on Zoom. I will be in the background monitoring those. At the end, I will share them with Professor Atkinson, and she will ask them of our guest. Again, thank you everyone for joining, and I will now turn it over to Professor Atkinson.
Hi, good afternoon. Thank you so much, Adam, for that kind introduction. So again, my name is Abbye Atkinson, and I am so pleased, and it's a privilege for me to get to have this conversation with our own Berkeley Law Dean Extraordinaire and the Jesse H. Chopra Distinguished Professor of Law, Erwin Chemerinsky. Good afternoon, Erwin. How are you?
Thank you, Abbye. Thank you so much for doing this.
Oh goodness, it's a privilege. And just because my Jamaican mother would be horrified that I would be having this conversation with you in public and calling you by your first name.
Oh, please call me by my first name. Please, we are colleagues and we should refer to each other by first names.
Very good, very good. Okay, so that taken care of in good lawyerly fashion, I want to start by laying out what I hope will be the roadmap for our conversation this afternoon. So first we'll talk Supreme Court term, 2021-22 term. I just draw out a couple of the controversial and more interesting cases. And then I want to spend some time talking about the White House Commission, the preliminary draft report issued last month on the Supreme Court. I want to probe and sort of find out selfishly some more. I have some questions for you, Erwin, just about you and your life and the law and, you know, how you find yourself, how we find ourselves here in this space, with a caveat that I also want to reserve some license to let the conversation take us where it may, and then open up for questions. I'll start by saying, it's especially a privilege because we started at Berkeley Law on the same day, July 1st, 2017. And so it's been a privilege to experience what, this is my 5th year now here with you as my boss, Erwin. So hello. And okay, so let's talk the term. So there are abortion cases that are often controversial, whether or not, one question for you generally is just whether you think the abortion cases are legally interesting or if they're just substantively controversial. So I want to talk about the 2 abortion cases, Dobbs and Whole Woman's Health v. Jackson. And then I want to talk about an immigration law case. And lastly, spend a little time on the free exercise clause case, the Macon case. So just for the benefit of our audience, I'm going to just give a couple facts and then the question presented, and then ask you some questions about these, how you think the court's going to approach these issues. So first, abortion cases. So there's Dobbs v. Jackson Women's Health Organization. This is a case that originates in Mississippi. It concerns the Gestational Age Act, which Mississippi passes in 2018, and it purports to prohibit abortion after 15 weeks, except where the pregnancy might endanger the mother's life. And so then this sort of 15-week mark is somewhat arbitrary because it's made without reference to the viability jurisprudence that we get from Roe and its progeny, particularly Casey. So both the district court and the Fifth Circuit find that this law is unconstitutional. And so the Supreme Court is taking up the following question presented then, which is whether all pre-viability prohibitions on elective abortions are unconstitutional. So similarly, coming out of Texas, and this is the case that has been in the news a great deal since about August. So there's Whole Woman's Health versus Jackson. The facts of that case is that Texas passes SB 8, which bans pretty much all abortion procedures after 6 weeks of pregnancy. And it does so, however, in a very interesting procedural mode, which is it authorizes a private right of action in which citizens, ordinary private citizens, including non-Texas residents, can file civil actions against the doctors and other individuals who aid the patient in getting the abortion. So the story is that the law is constructed in this way as a means of insulating it from any meaningful judicial review. And the petitioner here, Whole Woman's Health, asks for a stay of the law pending some determination of its constitutionality. We've heard stories about, then this comes up in the Supreme Court's so-called shadow docket. The real question before the court then is engaged with the substance ultimately, which is whether a state can insulate from federal court review a law that prohibits the exercise of a constitutional right by delegating to the general public the authority to enforce the prohibition through civil actions. Now, one last bit before I turn it over to you to share your thoughts, Erwin, which is that the Justice Department gets involved in September, which sort of helps to usher all of these sort of streamline and fast track these cases so that the Supreme Court normally wouldn't hear so quickly a sort of substantive challenge like this. So because the Justice Department gets involved, the Supreme Court agrees to take up the issue and sort of was going to think about all these cases together. And the court heard oral argument on November 1st. So there's a backdrop for these issues. So maybe you can start just sort of by teeing up the evolution of Supreme Court's abortion jurisprudence to then say, what you think, what you make of these cases.
Sure. In answer to where you finished, the Supreme Court's abortion jurisprudence, I think it's familiar with everyone. In 1973, in Roe versus Wade, the Supreme Court held that women have a fundamental right where they choose to terminate their pregnancies up to the time of viability. Viability being when the fetus can survive outside the womb. In 1992, in Planned Parenthood versus Casey, the Supreme Court said it was reaffirming, quote, the essential holding of Roe versus Wade, that states can't prohibit abortions prior to viability. Medicine science say that viability now is about the 24th week of pregnancy. The Mississippi law that you described prohibits abortions after the 15th week of pregnancy. The Texas law prohibits abortions after the 6th week of pregnancy. So I thought, Abbye, in response to what you said, I would make 3 points. First, ask, how important are these cases? On every level, they're enormously important. They're important in terms of women's lives. When you look at women who each year choose to have abortions, this would take away that right from them. In terms of the more general question of personal autonomy, if Roe versus Wade is overruled, what about all the other cases that deal with aspects of privacy and autonomy? How will they or will they survive? Also, it raises basic questions about how should the Constitution be interpreted? Should the court look only at the original understanding in 1787 or 1868? And then, of course, there would not be protection of abortion rights. Or is it a living Constitution that should include protection of autonomy and abortion rights? Second, I thought I'd address Dobbs because it's the case that directly deals with abortion. It's the Mississippi law that prohibits abortions after the 15th week of pregnancy. There's no doubt it's inconsistent with Roe and Casey because it's prohibiting pre-viability abortions. There's 3 things the Supreme Court might do in Dobbs. One is they could affirm the lower courts and strike down the Mississippi law. They could follow Roe and Casey. Most people think that's unlikely. Most people think there's 5 justices, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, who will vote to uphold the Mississippi law, and maybe Roberts is a 6th vote. A second thing the court could do is uphold the Mississippi law and say that states can prohibit abortions after the 15th week of pregnancy, but go no further than that. The court would then not express an opinion about laws that prohibit abortions, say, after the 6th week of pregnancy, like Texas, Ohio, Iowa, or like Alabama that prohibits abortions from the moment of conception. That would be left for future cases. Or third thing the court might do is just overrule Roe versus Wade. Some believe that the 5 justices that I mentioned want to overrule Roe versus Wade. We know from their prior writings, either on the Supreme Court or a lower court or off the bench, that these 5 justices believe that Roe was wrongly decided. So the stakes in Dobbs could not be higher. My third point goes to the Texas cases that you mentioned that were argued a week ago Monday on November 1st. The issue of abortion obviously underlies these cases. It involves Texas's SB8, and yet the actual issues to be decided by the Supreme Court are not about abortion rights, but issues of federal jurisdiction. In Whole Women's Health versus Jackson, the question is, can state officials be sued for an injunction if state officials play no role in enforcing the law? As you said, it's a law that's enforced by civil suits. And if the Supreme Court were to say there can't be a suit to enjoin the law, then what's to stop a state from adopting a law that says that civil suits can be brought against those who perform same-sex marriages, even though there's a right to have a same-sex marriage? Or civil suits can be brought against those who have firearms, even when it's lawful to possess one. Or civil suits can be brought against those who criticize the governor. The defendant in any of these suits could, as a defense, argue the law is unconstitutional, but that wouldn't leave or allow for an injunction to halt the enforcement of the law. I was encouraged at the oral argument that 6 of the justices, Roberts, Kavanaugh, and Barrett, along with Ryerson and Kagan, seem to clearly think that there can be a suit against state officials to enjoin the law, even if state officials don't play a role themselves in enforcing the law.
Great. And so, I'm sorry, I was going to say, so one possible outcome then, between these 2 cases is that in Mississippi, we might get some significant rollback of the substantive abortion right itself, and still leave the court able to say it doesn't like the sort of attack, if you will, on the jurisdictional questions.
If you were to ask me for a prediction, I think that the Supreme Court is going to say in Whole Women's Health versus Jackson that there can be a suit against state officials to enjoin the law. think in the other case you mentioned that was argued, United States versus Texas, don't think there's going to be a majority to say that the United States here can sue on behalf of women in Texas. But then when it gets to Dobbs, which was decided this spring, I think the court's going to cut back on or overrule Roe versus Wade.
That's a pretty grim prediction, Erwin, but it sounds right to me. I want to pick up then on, well, two strands. The first is this sort of the prominence of the shadow docket, and there's that issue. And I think the Texas case, Whole Woman's Health, sort of brought to the fore, at least the public consciousness, the notion that the Supreme Court not acts in ways that outside of just the traditional, reading opinions from the benches after hearing the cases on the merits. So what are your thoughts on the shadow docket? Can you describe for us what the shadow docket is and how you feel about the court's sort of decision-making process vis-a-vis the shadow docket?
The shadow docket simply refers to matters that come to the Supreme Court for an emergency ruling. The court is asked to issue an emergency preliminary injunction, or the court is asked to stay a preliminary injunction from a lower court. This is not new. There's always been the ability to go to the Supreme Court for an emergency order. There's always been instances of people on death row facing execution go to the Supreme Court for a last-minute emergency order to stay the execution. What changed is that the Trump administration went to the Supreme Court for such emergency orders vastly more often than any prior administration. The Trump administration in 4 years went to the Supreme Court for orders on the shadow docket 3 times as much as the Obama administration did in 8 years. And often this was in the context of President Trump would issue a policy that was alleged to be unconstitutional or illegal. A federal district court would issue a preliminary injunction. The Court of Appeals wouldn't touch it. And then the Supreme Court, often 5-4 on the shadow docket, lifts the preliminary injunction. I'll give an example so it's not abstract.
Yeah.
After Congress refused to appropriate funds for President Trump to build the border wall, President Trump diverted Defense Department funds on his own to do this. A federal district court issued a preliminary injunction saying the president didn't have the authority. The Ninth Circuit didn't lift it, but the Supreme Court, 5-4, lifted the preliminary injunction. I'm critical of the shadow docket because of the court's inconsistency in using it. And I'm critical too, on a more technical level, of the court seems to be ignoring the standards of appellate review. As you know, whenever a Court of Appeals is reviewing a lower court, the standard of review matters enormously. Is it de novo? Is it clear error? Is it abuse of discretion? When you write a brief in the Ninth Circuit, many circuits, for each issue, you have to state what's the standard of review. Generally, to stay a preliminary injunction or to grant a preliminary injunction that was denied below, an appellate court has to find an abuse of discretion. But the Supreme Court seems to be completely ignoring the standard of review when it's handling these cases on its emergency docket, its shadow docket.
So how do we find a balance between, so if the concern is not the docket itself, but the court's use or an administration's use or any party's use of the docket to sort of, make an end run around the time and process it would otherwise take to have their claim heard more traditionally, I suppose, in terms of timing. How do we resolve that, right? What is the limit on discretion of use then that's necessary to sort of cabin the abuse of the use that you're describing?
Ultimately, it has to be up to the justices themselves. I don't see a fix other than that. And my hope is that publicity about the shadow docket, criticism of how it's been used, justices like Justice Sotomayor in dissents criticizing the use of the shadow docket will cause the court to be more principled and adhere more to the levels of appellate review than what we've seen so far. But I don't see a fix other than that.
So you mentioned Justice Sotomayor's dissent, and I want to pick up there to get to the other part of your prediction about what's likely to happen to abortion rights. So in her dissent, she starts one section with the phrase "on a human level," right? And thereafter, she describes some of the record that the district court developed about how catastrophic the effects of SB 8 in Texas and the inability to get an abortion would really, the toll it would take on poor women, on women generally, and then certainly poor women who don't have the resources to leave the state to be able to get an abortion. And this then leads to questions of who, demographic questions, who are likely to be poor women. So this is going to fall predominantly on women of color, poor women of color. And it seems to me that, much of the reasoning in limiting abortion rights is rooted in this notion of protection of life and the state's interest in protection of life. But there's a limit, it seems to me, between whose life and protection of whose life is at stake. So what do you think about that? In the oral argument, did you get any sense that any of the justices are sort of thinking along the lines of Justice Sotomayor about the human effect, the well-being of life vis-a-vis the mothers and their families?
I think you put your finger on something very important. Justice Sotomayor has taken on the role of being the conscience of the court. And she's especially the conscience of the court that involves people of color and people from disadvantaged backgrounds. Can point to an opinion now 5 years ago in a case called Utah versus Street that involves the ability of police to benefit from illegal stops by letting the evidence come in at trial. And she wrote a powerful dissent talking about policing in minority communities. She spoke of the talk that parents have to give to their children about interacting with the police. She was self-consciously writing as a woman of color. And I think you see the same thing in oral arguments. She's willing to be outspoken in the liberal conscience of the court. In the way I think Justice Ginsburg was, they're not necessarily on issues of race. And I think it's so important to have a justice with a voice like that on the Supreme Court.
Indeed. So as you know, I'm teaching poverty law this semester, and you kindly came in and gave a guest lecture on the court's very limited poverty law jurisprudence, at least explicit poverty law jurisprudence, because one way to think about these cases is that they are in fact part of the court's poverty law or poverty jurisprudence insofar as it disproportionately affects poor families. But in those cases, poverty law cases, sort of well-known cases that come late 60s, early 70s, you often see, it's sort of a trade-off between Justice Brennan or Justice Marshall functioning as, sometimes Justice Blackmun functioning as the conscience of the court. In a world of, balls and strikes, as the Chief Justice would say, what work does a conscience of the court do practically?
It's interesting that over the last, say, 6 weeks, a number of the justices were out giving speeches about how the justices are, to use your phrase, which was Chief Justice Roberts, just calling balls and strikes. Amy Coney Barrett gave a speech at the McConnell Center at the University of Louisville saying, quote, "Justices are not partisan hacks." Justice Thomas then gave a speech at Notre Dame saying, "The personal views of the justices, like on questions like abortion, have nothing to do with how they decide cases." Justice Alito gave a speech at Notre Dame, especially about the shadow docket, saying, "We're not a sinister cabal." And following these, Justice Sotomayor did a talk at a program for the American Bar Association who said, "People are going to be really disappointed in what the Supreme Court does this year. Watch my dissents." The reality is, we all know that who's on the court and their values, their ideology, their life experience is determinative in so many of the cases. Why did the Republicans fight so hard to block the confirmation of Merrick Garland? Why did the Republicans worked so hard to rush through the confirmation of Amy Coney Barrett, because they know as well as you and I do that in cases like this, the composition of the court matters tremendously. If Hillary Clinton had gotten elected president in 2016, and if she had picked the replacements for Scalia, Kennedy, and Ginsburg, we wouldn't be talking today about whether Roe versus Wade might be overruled. One quick anecdote, I apologize in advance, I'm going to use a profanity. A number of years ago, I was at a conference of Federal Court of Appeals judges. I was going to have the pleasure of speaking. And before it was my turn to talk, Justice Scalia was the speaker. And he said that his views on issues like abortion and death penalty have nothing to do with how he votes in those cases. Several tables away from me was then Ninth Circuit Judge Stephen Reinhart. And he said, not in a whisper, bullshit. And there was a huge laugh from that part of the audience. And we all know that Judge Reinhart was right, that Justice Scalia's ideology made all the difference. And it does for the liberal justices just as much. There's no such thing as value neutral judging, not on the issues that come to the Supreme Court.
Yeah, so, I mean, I should police myself because I want to go to this discussion exactly, and I do want to talk about a couple of other cases, but, since we're here, it seems to me that it's true that, those of us who might take a more progressive view of what the court should be doing here are also expressing a set of value judgments about the world. So if that's right, and I'll try to fold in, what's the objection? Is it really an objection about the process, the means by which we now have a court that has 6 conservative justices and 3 liberal justices? Or, if the issue is value-based judgment, ideological judging, then we see ideological judging in Justice Sotomayor's dissents. So what do you make of that?
All of the justices are making value choices. Some of this is because the Constitution is written in very open-ended language. It uses words like liberty and equal protection and cruel and unusual punishment. There's no value neutral way of giving meaning to those phrases. More important, all constitutional cases involve a form of balancing. It's always balancing the competing interests. If it's a fundamental right, or say race discrimination, then the government has to meet strict scrutiny and has to show a compelling interest. If it's certain rights, sex discrimination, it's intermediate scrutiny and the government has to have an important interest. For all other types of discrimination, the government needs at least a legitimate interest. What's compelling or important or legitimate? There's no answer to that can be found in framers' intent. It's a value choice. In the affirmative action cases, the question the Supreme Court is focused on is whether diversity in the classroom is a compelling interest. In the marriage equality cases, at the very least, the issue was, does the government have a legitimate interest in stopping gay and lesbian couples from being able to marry? There's no way to answer that question other than the views of the justices. But I think you now see these justices going out and saying, oh, it has nothing to do with our views, because they want to make it seem that when they overrule Roe versus Wade, or protect gun rights, or protect religion from government regulation, it's not about them. They're just following the Constitution. Right, nonsense. It's all about them. It's always about who's on the court.
So you raise, just trying to be mindful of our time here. So because you've raised a reference to ultimately the Carson v. Macon case, which deals with the state's ability to regulate religion, let me skip to that as our sort of last case we'll discuss before we move on more broadly. So this case involves a Maine statute, a scheme that Maine apparently has limited high schools. Not every school district has a high school, so students sometimes have to step outside of their sort of district to find the free education to which they're entitled under the Maine Constitution. And so Maine has a program that assists with tuition, but the program excludes schools that are related to religious groups or organizations. So a couple parents who wanted to send their kids to religiously oriented Christian schools object on the basis of free exercise. In the middle of that, the court decides Espinoza that tells Montana that a similar kind of attempt to limit public benefits to religious organizations violates the separation of church and state, in essence, under their state constitution. The Supreme Court says Montana's wrong in Espinoza, and so Carson has to consider that. So the issue before is, does a state violate the religious clauses or equal protection clause of the US Constitution by prohibiting students participating in an otherwise generally available student aid program from choosing to use their aid to attend schools that provide religious or sectarian instruction? So what are your thoughts? The courts have not, the court has not yet heard argument on this case, I believe.
Case will be argued December 8th. There's been a major change in the law when it comes to the religion clauses. That the place where I think we've seen the most immediate shift in the court's jurisprudence because of the new justices is with regard to separation of church and state. For decades, the issue was, when may the government choose to give aid to religious schools without that violating the Establishment Clause? And so there are cases about, can the government provide audiovisual equipment to parochial schools if it's giving it to secular schools? Can the government give sign language interpreters to religious schools if it's giving it to secular schools? Can the government provide buses for field trips to religious schools if it's providing it to secular schools? Always asking, is the choice by the government to do that a violation of establishment of religion? Now the issue is totally different. Now the issue is, when must the government give aid to religious schools or denies free exercise of religion? The first case about this was in 2017, Trinity Lutheran versus Comer. Missouri was giving aid to schools for surfacing playgrounds. It would give the aid to public schools or secular private schools, but not religious schools. And the Supreme Court 7-2 said that violates free exercise of religion. Chief Justice Roberts, writing for the court, said, when the government gives aid to secular schools, free exercise requires that it give the aid to religious schools, unless doing so would violate the Establishment Clause. Justice Sotomayor wrote a dissent joined by Justice Ginsburg, where she said, this is the first time in history the Supreme Court has ever required the government to give aid to religious schools. This is the context, Abbye, for Carson versus Macon. There are places in Maine, as you say, that are too rural to support public school systems. So in those areas, there's a school administrative unit that gives money to parents to send their children to private school. It must be a secular private school. 2 religious schools and 2 parents brought a challenge to this and said, for the government to provide aid for secular private schools, but prohibit that from being used in religious private schools, violates free exercise of religion.
And so what do you think the court's gonna do here?
I'd like to see the Supreme Court say that this is different from the earlier cases. I'd like to see the Supreme Court say that the state has an interest in not using its funds to support religion and the indoctrination of religion. I'd like the Supreme Court to say that the earlier cases that you and I were talking about, like Espinoza and like Trinity Lutheran, all involved state constitutional provisions that came about. They were known as Blaine Amendments. In the 19th century, a Senator, Blaine, required that states include in their state constitutions prohibition of direct or indirect aid to religion as a condition for admission to the United States. The Blaine Amendments were motivated by a strong anti-Catholic sentiment. And I'd like the Supreme Court to say, that's different than Maine because its state constitution long precedes the Blaine Amendments. I think what's more likely is the Supreme Court's going to follow the 2 cases you and I were mentioning. I think the Supreme Court's likely to say the government is constitutionally required to give the aid to private religious schools that it's giving to private secular schools.
How much of this, coming back, and we'll switch to the, a little discussion about the President's Commission on the Supreme Court, and just to think about the ways in which the Supreme Court seems to be going about its business these days. many of the justices are sort of openly Catholic, and openly their conservatism perhaps is rooted in some of their Catholicism, seemingly, or just sort of religious affiliation. How much of that do you think is fact? If we're talking about value judgments, it's not just sort of conservatism writ large, but how much do you think their sort of religious understanding or views of the world might infuse their views about a parent's right, for example, to send their child to a Christian school as well as to a secular private school?
We're all a product of our upbringing, our background, our values, and our ideology. There's no way for anyone to divorce that from how they rule in a particular case. I, of course, believe that no one should be appointed or denied a seat in the Supreme Court on account of religion. It is striking that 6 of the current justices are Catholic. One is Episcopalian, but was raised Catholic, and the other 2 are Jewish. I don't think that's coincidence. I think that Republican presidents wanted very much to send a message to their base that they were appointing justices who would vote to overrule Roe versus Wade. And I think that by picking the justices they did, they were conveying that message to the Republican base that's anti-abortion rights. But there's no doubt that for all of us, our religion is part of who we are and would influence what we do as justices or judges.
Sure. I mean, indeed, I believe Justice Sotomayor is Catholic as well. So, yes. Her understanding of what that might, require her to, or how it might require her to view the world, obviously is an example of different values, different points of view.
As was William Brennan, who was always in the majority in the abortion rights cases, a Catholic. Yeah. So it's not that somebody's religion dictates how they're going to vote. There's Catholics on both sides of the issue. But it is striking to note the religious composition of the court. Again, saying I don't criticize a president for appointing somebody of one religion or another. There should never be a religious test for any office. But we should at least be cognizant of the religious affiliations of the current court. It's not a coincidence.
So with that, I want to lead us to talk about then, the court is, maybe in some circles, maybe in others it's fine, but experiencing sort of a crisis of legitimacy in light of how, I would say perhaps mostly Justice Gorsuch's appointment and over our now Attorney General Garland's nomination, and then sort of the fast track approach to the approval of the appointment of Justice Barrett. So the president, of course, Justice President Biden commissioned a group of experts to study the Supreme Court. There have been a lot of calls in the popular media and beyond for some sort of recalibration of the Supreme Court, given the sort of ideological mismatch, or what's the word? The skewing, the ideological skewing that we seem to experience these days. This commission then issued sort of a draft report and determined, just as a legal matter, that it was within Congress's sort of broad power to structure the court, meaning expand or contract its members. But there was significant dispute as to the prudential aspect of that kind of move. And the committee in this draft is split on whether adding more justices to the court, for example, to sort of balance out the ideology would be advisable, funnily enough, in light of legitimacy concerns. So what are your thoughts on these preliminary findings, given your conclusion that in addition to religious affiliation and political affiliation, there is political perspective doing some significant work here?
I agree with the premise. The Supreme Court's approval rating is the lowest it's been. In a Gallup poll in late September, it's only 40%. The disapproval was at 53%. The commission predates that. After Amy Coney Barrett was rushed through for confirmation in the Senate, the proposals to reform the Supreme Court. Joe Biden, as a candidate, was asked about them, and he did what a reasonable politician or dean often does. I'll create a committee to study it.
Yeah.
And that's the committee. In the 1970s, there were two different commissions to study the Supreme Court. One was chaired by a very famous Harvard Law professor, Paul Freund, the other by a Supreme Court Justice, Lewis Powell. Each made detailed recommendations. Nothing ever came of them. I think that's likely to happen from this commission, though it says it's not likely to make recommendations. There's not a consensus, even among progressives, about whether to expand the size of the Supreme Court. The size of the Supreme Court is not set by the Constitution, as I think everyone knows. It's set by federal law. Congress by statute could change it. But even if the House of Representatives would pass a bill to add 2 or 4 seats to the Supreme Court, we know it would die in the Senate because of Republican filibuster. Another proposal, and apparently the commission is more widely in favor of this, would be term limits for Supreme Court justices. These would apply only prospectively after the current justices leave. But there's a disagreement within the commission as to whether it could be done by a statute or whether it would require a constitutional amendment. Those who believe the latter, and I'm among them, say Article 3 gives Supreme Court justices life tenure. And if you're going to take it away, you've got to amend the Constitution. There's an alternative view that says, well, Congress could by statute leave them with the title and salary of justices and just have them hear Federal Court of Appeals cases. I'm skeptical because I don't think you're a justice if you're not hearing cases on the Supreme Court. Yeah. But I don't foresee anything coming of this. Certainly, I don't think there's going to be a constitutional amendment. No one seems to care enough to be the constituency to do the hard work that's necessary for a constitutional amendment.
Do you think that similar to your prescription for solving the shadow docket problem, that the court itself will have to solve its legitimacy woes as a consequence of the justices, and perhaps you're noting that they're out in the world giving speeches trying to do a bit of PR about how they're thinking about the world. Do you think that it's up to the court itself then to rebalance itself in some meaningful way?
Ultimately, yes. I don't think the speeches of the justice are going to make the slightest difference. Self-praise never gets much weight. Any person praising themselves or the place where they work is always taken with a grain of salt. So the justice is saying, oh, this has nothing to do with our views, doesn't persuade anybody except those who already agree with them. I think one thing that contributes to the legitimacy problem of the Supreme Court is not of the justice's own making. It's a result of right now, all 6 conservative justices were appointed by Republican presidents, and all 3 liberal justices were appointed by Democratic presidents. That's new. Until recently, we had justices who were appointed by Republican presidents who were liberal on the Supreme Court. John Paul Stevens, David Souter. Justices who were conservative were appointed by Democratic presidents, Byron White, before that Felix Frankfurter. But having the political party of the president who appointed them so correspond to the ideology of the justices, I think increases the sense that it's really about politics and ideology. I don't see how that's going to change. Also, I think we have 5 conservative justices who are much more conservative than where most of the American people are ideologically. I've always thought on an ideological continuum, the American people are somewhat just to the left of center or just to the right of center. Democratic presidents have won the popular vote in every presidential election since 1992, except in 2004. On the other hand, Donald Trump was elected president. But 5 justices, Thomas, Alito, Gorsuch, Kavanaugh, Barrett, are very far to the right. What will it mean if they're handing down decisions that are consistently out of step with the views of most of the American people? Opinion polls show about 2/3 of the American people think that Roe versus Wade should not be overruled. If these 5 justices overrule Roe versus Wade, I think it'll be another blow to the public opinion ratings, the approval ratings of the Supreme Court.
So, I mean, that raises for me, and goodness, I haven't even gotten to all the good stuff that I want to ask you about yourself, but I think this bears asking. Why should we normatively want a court that reflects the sort of broader political ideology of the country? And I ask this thinking specifically about issues of race, right? I imagine when Dred Scott was decided, most of the American populace who were not African American and affected by that decision probably weren't as outraged as many Americans would be now in thinking about a similar sort of decision. And I would hate to think that that would be the measure by which we decide whether or not the court's doing its work well.
And I didn't mean to imply that. I think we can have two different conversations. One is a more normative one. Should the Supreme Court's decisions reflect the overall attitudes of the American people? And I'd emphatically say no. Brown versus Board of Education was terribly unpopular when it came down, but it is the epitome of what the Supreme Court exists to do. So I do not mean to imply normatively we want the Supreme Court to do what the American people want. Or we could have a descriptive conversation about what's the Supreme Court's approval rating and legitimacy and what accounts for that. And I think overruling Roe, when 2/3 of the American people think it shouldn't be overruled, will be a further blow to the Supreme Court's approval rating. And I was much more addressing the latter, not the former, in terms of what should the Supreme Court be doing.
I guess why should we worry about the latter then? Why worry about the descriptive right? To the extent that there were many people in the US population and I'm going to test my lack of common knowledge here, is Brown decided in 1954, who may have decided that this is a terrible decision. But we look back on it fondly, notwithstanding the sort of descriptive story one might tell about Brown in 1954 and 1955. So why do we care more? Why should we care about the descriptive over the normative?
I'm not sure that we should. And I've argued in print that there's been far too much focus on that. There's justices like Felix Frankfurter, scholars like the late Alexander Bickel, or Jesse Chopra, the former dean of this law school, who have really said we should have theories of judicial review to maximize the legitimacy of the court. And their attitude is the court, in the words of Alexander Hamilton, lacks the powers of the purse and the sword. All it can do is persuade. And if the court loses its legitimacy, it's not going to be able to do that. It will just be ignored. I take a different view than that. I think the role of the Supreme Court is to enforce the Constitution, especially protect minorities and minority rights that aren't going to be protected through the political process. And I think the court's job should be to do that without worrying about its legitimacy.
Sure.
And yet we can also have a conversation about why is the Supreme Court's approval rating where it is, and is that something we should care about?
Right. Okay. I have been overly indulgent in hogging all the questioning time. And so we have some questions here, some audience questions, Erwin, so I'm going to pose them to you. So first question, a frequent, at least in my family, critique of the court is that it has become too political. What would you say to lay people and lawyers who argue that politics is a new feature of the court and that it is objectively a negative feature?
I think it's very important to use the word political precisely. In one sense, the Supreme Court isn't political. You can't lobby Supreme Court justices the way that you can lobby city council members or state legislators or members of Congress. Supreme Court justices, so far as we know, don't trade votes with one another as we accept log rolling from members of a legislature. But if what we mean by political is ideological, the Supreme Court always has been ideological. Marbury versus Madison in 1803 wouldn't have come out the way it did, but for the ideology of John Marshall. From the 1890s to 1936, the Supreme Court struck down over 200 laws protecting consumers and workers because of the conservative ideology of the justices. Brown versus Board of Education wouldn't have come out the way it did, but for the ideology of the justices who made it happen. So I don't think that ideology plays a larger role today than it has before. I think what's different now is we have a court that is much more defined ideologically, probably than at any time since the end of the Warren Court. Then you had a majority that was liberal for the first time in history. Now you have the most conservative majority on the court that we've had, at least since the 1930s. But I think ideology is always a part of Supreme Court decision-making. It's inevitable, and it's not more now than it used to be.
Thank you, Erwin. So next question. There's been a lot of erosion of abortion rights since Roe was decided by states taking procedural steps for health and safety, etc. If the Texas approach to block abortions fails here, what other angles might states try to take next that would have a better chance of prevailing?
Absolutely right. States have adopted literally hundreds of laws to try to create obstacles for women being able to have access to abortion. The Supreme Court has upheld some, like the federal ban on so-called partial birth abortions. The court struck down others, like requirements that doctors have admitting privilege to the hospital within 30 miles where abortions are performed. But I think there's a huge difference between regulation of abortion and prohibitions of abortion. Because if the Supreme Court overrules Roe, over half the states will prohibit abortion entirely in all or virtually all instances. Now, I want to go to something that Abbye said. Women with money in those states will travel to the states where abortion remains legal, like California and New York. Before New York was the first state in this country to legalize abortion in the 1960s, over a quarter of all of the abortions in England were performed on American women. It wasn't poor women who were going to England for abortions. It's poor women, which is, race corresponds with poverty in this country, especially women of color, teenagers who won't have access to abortion. I think if the Supreme Court were to strike down the Texas law in the end, we're still going to have the question of, can states prohibit abortion at the 8th week or the 10th week, or like Mississippi law, the 15th week of pregnancy? And I think in the unlikely event the Supreme Court strikes down the Texas and Mississippi law, then we get to the question posed, what about all the other regulations of abortion? Restrictions on the ability to use telemedicine to prescribe abortion by medication rather than by surgical abortion, which is so important. Long waiting periods for abortions before they can be provided. Ever more detailed informed consent requirements, including requiring that women look at ultrasound pictures of the fetus before an abortion. We can go on with the endless regulations. I worry, though, that we're going to go out of the realm of what regulations are allowed, and in Dobbs get to the ability of the state just to flat out ban all abortions.
Next question is it likely that the Supreme Court will allow more media access as they're having empty chambers except for arguing attorneys?
We've had a major change in this regard since May of 2020. Prior to May of 2020, the Supreme Court never allowed live broadcasting, audio or video, of any Supreme Court proceedings. The best they did was after oral arguments were over in very high-profile cases, like Bush versus Gore, is release the audio tapes immediately rather than later at the end of the week. But since May 2020, the Supreme Court has allowed live audio broadcasts of its arguments. I, and maybe many of you, listened to the arguments a week ago Monday morning on November 1st in the two cases involving the Texas law. I think the Supreme Court is going to continue to allow the live audio broadcasts. I think the justices are still resisting, and resisting strongly, allowing cameras in their courtroom. I expect at some point that will change. Federal courts of appeals have long allowed live video streaming and archiving of the videotapes, but the justices aren't there yet.
Why do you think they're resistant to their video, their likenesses being portrayed in this way?
I can tell you the arguments that I've heard them make, but I'm not very persuaded by it. They believe that if there's live video broadcasts, then clips will be taken out of context, and the news will then have those out of context clips that will be embarrassing to them. Of course, now that's true of any live proceeding. It's true of what goes on in Congress or anywhere else. But I think they're very afraid of that and worried that it will further hurt their legitimacy. I think that all of us feel a little bit more uncomfortable when we're being watched.
Sure.
And, somebody comes into your classroom or my classroom to watch and evaluate us. I think the justices feel that in kind it's different to have video their proceedings than now just to have audio tapes. I think they're wrong.
Yeah.
I think what the Supreme Court does affects all of us, often the most important intimate aspect of our lives. Very few people, even when the courtroom is open, can make it there. We should all be able to see the justices doing their work.
Yeah, I agree. As much as I myself, in the time of the pandemic, it's uncomfortable to be recorded, but sometimes it's necessary. I have one question I'm going to pick out to ask you. There isn't, nearly enough time for you to answer this, but it's something that's sort of been come up and pressing for me. So the Chicago Law Review has recently published, and this is, we're going to move away from the Supreme Court and think about legal education and scholarship, recently published an essay, reformed essay about who's most cited legal scholars. You're on the list, Erwin. I'm sure, like, surprise, surprise, you're on the list. I think you're somewhere around 21 of the first 50. But of that top 50, as I could see, there were two women, Catherine McKinnon at number 40 and the late Deborah Rohde at number 45. And, by my own guess, I think just one man of color. What do you make of this, Erwin? Right? How should someone like me, someone early in my career, a person of color trying to sort of exist in a space that is, decidedly not very diverse. What are your thoughts on this kind of information, both as a member of this elite 50, and then just sort of as a law dean, as a law teacher, as a trainer of the future lawyers?
There are many similar studies about citation counts. I haven't seen this one, but a new one just came out from Professor St. Thomas Law School, the Leiter Report. They all have the same thing as results you do. To start with, I think we should say citation counts are a really silly measure of anything. Now, citation counts also reflect how long you've been doing something. By virtue of being a law professor 42 years, I have more chances to have my things cited. It reflects field. The more you're in a field like constitutional law, the more you have a chance to get cited. It reflects the kinds of things you write. I've done treatises that tend to get cited more than, say, specialized articles. But all of this is why we shouldn't be focusing on citation count. What should we be focusing on? What we should be focusing on is supporting all of our faculty doing outstanding legal scholarship. I've read your scholarship, Abbye. You are a terrific scholar. I don't know how many times it's going to get cited, but that's not the measure of the quality of the scholarship. And so I think what we need to do is have much better, much more nuanced measures of quality. And what we have to do is everything we can to recruit diverse people into legal academia and do everything we can to support them when they're here doing terrific scholarship. And my hope is that over time, when we're not talking about the professors who started teaching like me in 1980, but the professors who started teaching like you in 2017. And when you're 40 years into your career, then there's going to be a much different list of people who are most frequently cited. But if not, that shouldn't matter because it shouldn't be the measure of quality of scholarship.
Thank you for that, Erwin. So we're out of time. It's gone very quickly. So thank you so much for being here with us. And I will turn it over back to Adam to close out the session.
Well, thank you so much, Professor Atkinson and Dean Chemerinsky. And thanks to all of you for joining us. I hope everyone has a safe and pleasant evening.